Welcome to an oral argument session of the 6th District Court of Appeal. I appreciate the introduction. My name is Dan Traber. I'll be presiding over today's session. We have two cases on our docket. Before I announce that, let me introduce you to our panel. Seated to my right and your left is the Honorable Jared Smith, and seated to my left and your right is the Honorable Eric Netcher. Judge Netcher, his day job is as a circuit judge in the 9th Judicial Circuit, and he is with us through the good graces of the Florida Supreme Court's Associate Justice Program, and we're really thrilled to have him aboard. This is being streamed live on YouTube. If you haven't already silenced your cell phones, we would be truly grateful if you did. Our first case on the docket this morning is case number 24-1015. Winter Haven Hospital, Inc., doing business as Winter Haven Hospital versus Carrie Howland, Mark Howland, et al. Ms. Stein, how much time would you like for rebuttal now?
5 minutes.
Whenever you're ready.
Thank you. May it please the court, Dinah Stein on behalf of Winter Haven Hospital. And we contend today that the trial judge was absolutely correct the first time around when she dismissed the uncorroborated medical negligence claim against the hospital, and she erred as a matter of law when she, on reconsideration while it was pending on appeal, reversed herself and held, based on plaintiff's argument about a conflict, which is incorrect, that it was not subject to dismissal. We also contend that the ruling below is absolutely reviewable by this court at this time. And I will start with the jurisdictional argument because, obviously plaintiff appears to be at least taking a position that when the Supreme Court ruled in Carmody, it was limiting the ability for courts like these to review any of these types of orders of noncompliance with pre-suit. The Carmody decision, to the contrary, realized how important it was to have interlocutory review of these orders and expanded the ability to review these orders by creating an appellate rule. It said, we're not changing the rule on certiorari. We can't. It doesn't allow discretionary type rulings about the quality of pre-suit. So we're going to allow an appellate rule for these quality-based rulings on pre-suit, and all the rest, which it called process related, it said that's still subject to certiorari, just like the Oken case held. And just like the courts have held, such as in the first district, the one that certified conflict in Carmody, in Pusha.
Can we start with 9.130? And there's two components for me that I want to ask you about. First, it has to deny a motion to dismiss on the basis of qualifications of a corroborating expert witness.
Yes, Your Honor.
As I understand the trial court's order, the motion to dismiss was granted on grounds other than the qualifications. Isn't that correct?
The motion to dismiss originally, well, there was a lot of discussion about his qualification, and it held that since Dr. Shashadi was an internal medicine doctor,
putting aside the qualifications issue, because it's clear that at a minimum the trial court disagreed with your position that there had to be compliance with pre-suit for a separate provider when the entity is allegedly vicariously responsible. But putting that aside, as I understand the trial court's order, they agreed that the complaint didn't state a cause of action because of the conclusory nature of it, insufficient allegations, and so they grant the motion to dismiss. So was there ever a denial of a motion to dismiss that is on review?
Yes, Your Honor,
Okay.
because the court did not dismiss with prejudice. And that's the problem, is that we were entitled to dismissal with prejudice because of pre-suit. The other thing, and I appreciate Your Honor's your question, it's important. This is an issue of whether the hospital is entitled to interlocutory review of a non-corroboration. We can't be kept in limbo like that and never have review.
That sounds like a cert argument, and then we can get to that. But on 9.130, I'll move to the second one. What about this particular order is on the basis of the doctor's qualifications?
So yes, Your Honor. So and I'd submit that the court did not discuss his qualifications for naught. She very specifically, I think on page 2, goes through his qualifications and says, I understand he's an internal medicine doctor. I find that sufficient because there was an internal medicine doctor at the hospital. And it's our position that it had to be from a board certified, or not board certified, but a qualified radiologist. So it is essentially finding that I find Dr. Shashady qualified because there are other potentially negligent employees at the hospital. So I do believe it falls into the appellate rule. But of course, we anticipated that, you know, in case that your honors disagree, then absolutely there's the safety net of certiorari, because the court, the Carmody court, never held that there's going to be the most egregious violations of pre-suit are just not going to be subject to interlocutory review. It recognized that these, and that's why it depends in some ways how you characterize the court's ruling. If you characterize it as saying that Dr. Shashady's qualified, then it is based on his qualifications. If you characterize it as just rejecting our argument that they failed to comply with pre-suit as to this claim, then it's certiorari.
Do you know, I don't know if it's part of this, of the record, but the status of the pleadings? Was there an amended complaint filed after the granting of the motion to dismiss?
I believe there is, and I apologize. I know that there is motion practice going back and forth, so I apologize for not knowing the
answer.
And
on cert, to the extent we're getting there, it sounds like you might have some agency arguments, some non-delegable duty arguments as it relates to the issue of vicarious liability. What do we do with that? Meaning, there's gonna be a lot of chance for this issue not to even be an issue ultimately at the conclusion of the case. And you are already there litigating, meaning traditionally when we think of cert, it's in med mal context, it's because you are being deprived of your right not to have to face this case. The hospital is already there litigating and interjected the issue of the radiologist. So how is this not remediable on appeal at the conclusion of the case?
So the courts have never distinguished it based on, you know, what if you win at the end? And it's never been either that or timing. So in other words, you know, there very well may be good defenses to the agency claim. That's never been the test on pre-suit. It's whether the defendant was received the rights it's entitled to under the statute. Period. The end. You know, if they don't make that threshold showing, they just don't get into issues like agency and force the hospital to defend itself on issues like that. Number two, there are multiple reasons for having this pre-suit. Some of them have to do with not just the corroboration, but the early opportunity to settle claims, to request arbitration, to investigate the claims during pre-suit. So it's not just corroboration that the hospital.
Posture, though, in this particular case, where your colleagues are going to assert or have asserted below that the radiologist didn't do anything wrong, or I'm sorry, that you're asserting that the radiologist did something wrong and they're not. So it seems to me that if I look at the way that this all started, going back to Williams, coming up through Carmody, we don't have an analogous sort of situation to what you're talking about.
Well, it is analogous in the sense of this, and that's plaintiffs have tried very hard to make the Fabre kind of like a mirror image of the claim. It's not. I mean, it's putting aside burdens of proof, and I think Guzman really speaks to this. A Fabre defense doesn't admit negligence, but of course it says, but if we are negligent, you know, the jury has to look at the whole picture. The Fabre defendant is not being asked to be responsible for this alleged negligence. They are not being asked to be out of pocket for the alleged negligence. It's a defense. Now, the mirror part of it, the non-mirror part of it is we're being asked now to answer for any alleged negligence of the radiologist. We're the ones who are a defendant who are going to be out of pocket because of that. And we're the ones who have the right in pre-suit to be able to investigate it, respond to it, perhaps settle it, and demand arbitration. So even though we're later in the case than Carmody, we're still denied the rights that we were entitled to at the time of pre-suit, and there's no exception to pre-suit and certiorari and appeal that says, well, look, if you've gone this long in litigation, it just doesn't matter. We could still be held liable for this claim that we were statutory allowed to investigate in pre-suit and do whatever our rights were.
Why do you suppose the second DCI on remand dismissed Jackman?
I don't know, because they never wrote an opinion. However, I think it could have been because they felt that since they called it a non-process related error, that they felt this would have fallen under the appellate rule, and we were well beyond the appellate time in that case. But there was, it's a bit mysterious. There's no answer to that.
Is one possible reason that in that case, just like in your case, you know, and this is kind of to my colleague's point, that the case is going to trial. You know, this isn't and if the jury returns a $0 verdict against your client, then you're happy, you don't care. And there's certainly no appeal that comes out of that from you. If we look at cert on an irreparable harm, kind of on that fundamental level, as opposed to how I think you have to try to cabinet, which is issue specific. Could you address that particular concern?
Well, let's first go to Jackman, and I think we know very clearly that that was not a concern of it, because it made it clear in its opinion when it said it didn't even get to the qualification level except for one part of the opinion. It said, you haven't even corroborated this, you're out. We grant certiorari. It had absolutely no problem other than the conflict.
That was before Carmody, though. Are you talking about the original opinion?
The original opinion, which recognized the conflict. It certified conflict, but it said otherwise we find the irreparable harm. And irreparable harm was not the issue with the conflict. It was whether there could be a departure from the essential requirements of law for these discretionary type rulings. So the irreparable harm element was never an issue with the second district. And you could look at the opinion and see that they were.
Well, I mean, they dismissed it when it came back after Carmody. That's why I was.
Right. No, it was. I'm very confident answering that by saying it would have been based on whether it was just reviewable on the essential requirements of law based on the Carmody conflict, because that's the only reason they just
Wouldn't you deny if you got to the merits as opposed to dismiss, though, if you got to essential requirements?
That's true.
That's where I'm asking you to dismiss, because when you talk about dismissal in remand in the wake of the Carmody decision from the Florida Supreme Court, it seemed like the second DCA was saying that we don't have jurisdiction over this cert petition.
I don't disagree with Your Honor as far as how they worded it.
Yeah.
I will.
But you think they misworded it in terms of that they had to have gotten to the essential requirements of the law?
Yes.
Okay.
Yes, and maybe there was another reason for using the word dismissal, but it just wasn't at issue in this cert petition as shown by the opinion.
On the essential requirements of law, and I guess we'll let you get to the merits at some point, but on the essential requirements of law, the Florida Supreme Court has this miscarriage of justice language. It's so what degree, we don't really have any appellate opinions. You did file your notice of supplemental authority from the third DCA on this issue about separate specialties for entity defendants like hospitals. But how clear does it have to be, and to determine that it was a violation of the essential requirements of law that results in a miscarriage of justice?
Yes, Your Honor. And I think maybe the easy answer to Your Honor's question is we have the statute. We have 766.203 subsection 2, which talks in terms of claims, not, does this support an action for medical malpractice, but claims, which then references, it goes back to 766.102 subsection 5, the qualifications. So, I mean, we could start right there from the basics, is that the statute now in its present form, by incorporating the revised 766.102, does require corroboration, period, the end, I would submit. Having said that, we now have the fourth district which has talked in terms of, and this is the Rafferty case, is something in the affidavit corroborating the claim, which obviously it's finding that Davis, its prior decision is no longer good law. It had to have. We have the Mann decision from the second district, which was not quashed by the Supreme Court. And of course, the Jackman decision, which, you know, you can look at as reference. But I think we do have a clear violation of the law, which says claims have to be corroborated. So that's probably the easy answer for both appellate review and certiorari. But as far as the merits, and I think, you know, that's the heart of it, is that the court originally was very comfortable, or at least, you know, did it based on Jackman and the other authorities dismissing the claim. It was plaintiffs that then came back with this concept from a journal, a plaintiff's journal, that that there's this law that says, and if you think about this, this is really what plaintiffs are saying. They can get a nurse to corroborate nursing claims against the hospital in pre-suit. And once it gets into litigation, as long as that nurse corroborated something, they can now bring claims for neurological negligence, anesthesia, surgery, administrative. They could bring negligent credentialing claims. That's the real fundamental problem with plaintiffs' argument, is that that was never what 203 and 105, and I'm abbreviating 766, were intended to do. There is a reason why the qualifications statute has been made very restrictive over the years. And so to suggest that there's exception to pre-suit for institutional defendants, I think is highly problematic. And it throws a wrench into all of these pre-suits where now we have, you know, plaintiffs can just come back. And again, they're doing this to try to get an advantage. I understand these are all excellent lawyers involved, but they're not allowed to do it. And they can't say now, we have to be responsible for a radiologist that they didn't feel we had to investigate in pre-suit, who, by the way, we had no ability to talk to during pre-suit. Yes, Your Honor.
You're into your rebuttal time. Do you want to save the rest, or do you want to?
Thank you, Your Honor. I would like to save the rest for rebuttal. Thank you.
Ms. Norris, good morning. Whenever you're ready, ma'am.
Good morning, Your Honors. May it please the court. My name is Kristen Norris. I'm here with Brandon Breslow of Kynes, Markman, and Fellman, and we represent the Howlands. Organize a little bit here. The court below did not misapply the pre-suit statutes when it ruled that the Howlands did not have to somehow preemptively corroborate a claim of negligence by Dr. Freed when the only parties actively alleging his negligence are the defendants. And that's just not supported by any possible interpretation of Chapter 766. It's also an order over which the court does not have jurisdiction. Did you have a question, Your Honor? Okay.
Not yet.
So I'll start as my fellow counsel did on the jurisdiction question. So yes, in Carmody, the Florida Supreme Court decided to expand Rule 9.130, but in a very specific, limited fashion to address orders denying dismissal on the basis of the qualifications of corroborating witness. And essentially, an order that may essentially or effectively do that is not enough. When we're talking about jurisdiction, we have to strictly comply with what is permitted. And all that's permitted is an order ruling on the basis of qualifications. If you look at the court's actual ruling, it's in appendix page 10. It goes through the case law in Davis, Columbia, Jackman, and it rules that the Howlands can amend their complaint without having corroborated every possible theory of negligence. So I disagree that there's any fulsome discussion of qualifications. That's not what the basis of the ruling was. And you need look no further than the briefing in which the hospital argues that the ruling was that a plaintiff suing a hospital need not separately corroborate multiple claims. So that takes us outside of the rule. So now we have certiorari jurisdiction. I don't think Carmody said you get review of all process-related claims, because I think that would be extremely broad. What Carmody said is they distinguished between the kind of case in which you've been deprived entirely of your pre-suit process. You've not had notice, you've not had an opportunity to investigate the claims. And
Seems like you'd have to look back at Williams and look at that language about procedure and due process. Could you address that just in comparison to this particular case?
right, so there's no argument that the hospital had the pre-suit procedure that is required. The Carmody talks about checking the boxes. Check the box, corroborating affidavit. Check the box, pre-suit discovery, interrogatories back and forth, open an authority for them to get access to any records they needed, the ability to conduct some pre-suit discovery. In addition, the notice here was notice of a claim on failing to diagnose and treat the punctured rectum during this specific hospitalization, and that it might include not only the corroborated doctors, but other people who are involved in that specific course of treatment.
How far do we take that? Can you respond to Ms. Stein's point relative to, could you pre-suit a nurse, have a qualified nurse,
Right.
And then discover during the course of trial, or perhaps know at the outset and just kind of sandbag and amend a year or so into the course of the litigation? What are the limits of your view as to how far that goes?
May I finish the jurisdiction?
Of
I just
course.
want to make sure I let me
I
turn
appreciate
to
that
that.
it bleeds into it.
Yes,
somewhat,
they-
because I'm trying to
they
figure out which box, meaning
Right.
they talk about checking the box, but it's a little unclear what boxes are supposed to be checked.
Correct.
So they bleed,
Correct.
but you can, if you want to address it on
Right.
the merits, you may.
So I think in this case, the due process aspect was met. And that's whether you look at Williams, whether you look at Carmody, you had the pre-suit procedure. In fact, there was no argument later that that was insufficient. And then I think in this case, what you also look at, and Judge Netcher, I'll turn to your question, is when you look at these cases, when you look at Davis and you try to reconcile it with Jackman or these other cases, at what point does your claim start to extend beyond what you actually pre-suited? I think that's where the tension in the cases is. But I don't think that's a concern here, because what was alleged was a failure to diagnose and treat. And what was investigated was a failure to diagnose and treat. It included Dr. Freed's records. Everybody had them. The onus is on both the plaintiff and the defendants to conduct a pre-suit review of all claims and defenses.
Let me ask you this. Do you concede that there's no dispute, correct, that Dr. Chachete is not in the same specialty as Dr.
Right,
Freed?
there is no
That's
dispute.
Not okay.
There is no dispute of that at all.
And I take it you would not be here making the same argument if you were seeking to add Dr. Freed as a defendant. Is that fair?
I don't know that we would. I don't know the answer to that question, because I do think that the corroboration requirements apply at the beginning of the case, and that this might be something that a plaintiff could do because it's within what the notice and corroboration were of the claim of medical negligence and failing to diagnose. So I think that the plaintiff may actually be able to do this type of amendment under some of the case law that's been cited. But fortunately, we don't have to decide that, because the plaintiff has always taken the position that this is not negligence by Dr. Freed. And so the only person asserting negligence is the defense. I think the judges.
I mean, but you've
Go ahead. Go ahead, Mr.
I mean, you are suing them on a theory that Dr. Freed was negligent. So I appreciate that it was interjected by the defense initially, but that doesn't necessarily mean that you have to then assert that they are also negligent.
Well,
I understand what you're saying.
Right.
If they are responsible, if Dr. Freed is negligent, then hospital, you are responsible.
Mm-hmm.
But they are not now the only parties claiming that Dr. Freed was negligent.
Mm-hmm.
Is that fair?
I understand your point, Your Honor, but I think ultimately what the hospital wants to do is avoid liability. And I think one of the things that we've touched on a bit here is we don't know how this case is going to play out. I think that's one of the reasons cert jurisdiction doesn't exist here. It's not a case in which the hospital would be released. It's not a case in which the hospital is actually suffering any real harm from the lack of the corroborating affidavit. They have an expert. They have determined that they think Dr. Freed was negligent. So even taking it out of the Carmody and whether you have to check all the boxes or some of the boxes or how many of the boxes, even if we take it out of there and you look at this case in a vacuum, is there a departure from the essential requirements of law when a judge rules that a plaintiff does not have to corroborate the negligence of a doctor that only the defense claims is responsible. Does a plaintiff, have to go through that process preemptively, even though the statute itself says the plaintiff is only supposed to corroborate those persons that it reasonably concludes is negligent? And then here, I think at this point, this is part of an earlier ruling that the Fabre defense was actually allowed at this late date, with the understanding that the plaintiffs would be able to plead in avoidance of it.
And counsel, that was actually going to be my question. You kind of answered it. When the concept of sandbagging is mentioned, I suppose there is the idea that on its surface, if we look at this case and we say, wow, you've got one affidavit from a nurse, and then later you try to bring up a neurosurgeon and his negligence or her negligence. Where does that? What kind of evils can come from that, and how much do we avoid the entire purpose of the statute and the plain language of the statute, frankly, to allow that? Your situation, I see, is quite different because you actually were not the ones that first brought up Dr. Freed. It was actually brought up by the defense, and it was brought up fairly close to the 9th hour. It wasn't, the week of trial, but it was after an extensive amount of discovery had occurred, frankly, well after the pre-suit requirements were done, and after you had asked them, is there anybody else involved in this during pre-suit? So everybody had a chance to throw out the name Dr. Freed, and it wasn't until what appears to be, too late of an hour for Dr. Freed to be out himself into the litigation. So as I looked at this and I saw what the trial court did, because everybody up here has been in that position of being a trial court judge, and we understand, when we have these unique situations that come before us, and we try to craft what we think is a fair result based on a very unique situation in the law. I saw what you had argued, where the trial court had apparently not chosen option A to just simply say, no, we're not going to allow the hospital to add Dr. Freed as a Fabre defendant. I'll pick option B, which is I'll allow Fabre, but I'm also going to allow them, the plaintiffs, to add Dr. Freed as well as a claim for vicarious liability, which seemed like a balanced strike to me. But my question to you is, if for some reason we did rule in the hospital's favor in this situation, do we then rule in such a way that we have to say, okay, now trial judge, you get to decide whether or not this Fabre even gets added again? And there are all sorts of issues that come up with that, but I wanted to hear from you, what would your position be on that? Do you believe that the ruling was tied together? Tell me in the record how clear it is that the trial court's ruling was tied with the Fabre and allowing you to add Dr. Freed as a vicarious liable defendant.
So they were tied to, those rulings were tied together. And I think what this really demonstrates is all of this is remediable on final appeal and as the whole nut, right? Was that ruling proper? Was the subsequent amendment proper? How could the amendment go forward? There's going to be future rulings. And they were tied together. It was at the hearing at which the amendment was argued that trial counsel said, well, if you were going to allow that, then we have to be able to plead an avoidance because that would be their agent.
I'm sorry,
yes.
You said the word avoidance now twice, and I'm wondering if that might not be the proper way that this should have gone down, meaning the affirmative defense is permitted, and then you're permitted to reply in avoidance, meaning they can argue that Dr. Freed was negligent. You can present evidence that they were an agent or that somehow the other side is responsible. If you are correct, they don't get to offset the judgment amount. If they are correct, they do get to. Not that you could get affirmative relief from the hospital on the basis of Dr. Freed's negligence. It seems like that's kind of what maybe the trial judge was attempting to fashion, and perhaps could avoid the issue of what do we do with this affirmative defense. I'm not saying we can do that in this case, but you've used the word avoidance twice, and it seems like that might be the proper way to look at this.
Right. And I think that I've used the word avoidance because there is some remedy here, but unfortunately, whether that remedy that the trial court fashioned or how it played out is not the subject of the review here, because this has been set up very specifically to talk about pre-suit, because that's the only thing that would give the non-final review. And so we're stuck not reviewing that aspect of it. And in fact, nobody argued that the vicarious liability in the motion, it didn't say the vicarious liability claim was improper for not affirmatively alleging negligence or for being a claim that would subject them. The only argument other than the sufficiency of the agency allegations was this pre-suit, and I think by design. So whether or not that's the proper, and again, this is something that will get played out as
And do
they
you know
get
what
to
the
trial.
status of the pleadings are now in terms of,
I
was there
do
an
know
amended
that,
complaint?
yes, Your Honor, and let me answer that. So there was, the court granted dismissal with leave to amend to more fulsomely address the agency. There was an amendment. There was then a subsequent motion to dismiss. This is in our appendix. I did put it in the appendix so that it is in the record. I do not know where it stands other than that there was going to be, another amendment, and then I don't know if that second amended complaint
Did your
stands.
client undertake any effort, and this may be an unfair question, as I understand the briefing, everybody sort of discovered this potential negligence at the August 2023 deposition of Dr. Freed. We're under 2 years from that point. Is there any world in which the pre-suit process could have started during the course of the litigation? Or does the statute of limitations foreclose that?
Okay, 2 questions.
Yeah.
The first being, did this really just get discovered? The plaintiff had Dr. Freed's records. The defense had Dr. Freed's records. The plaintiff provided, did the full pre-suit and provided corroboration only on the 2 doctors because those were the only ones they claimed was negligent. But Dr. Freed's records were definitely part of this pre-suit investigation.
The issue seemed in the deposition that he said something that wasn't in his records.
Right. It's not that he said something that wasn't in his records. It's that they didn't expect him to say that his report showed the concerning symptoms that people were looking for. And that now they think that he should have been more direct in his report, that it didn't fully alert them to what happened or that he didn't call them immediately. So they've developed this new theory about Dr. Freed, but he was part of the pre-suit records. He was part of the pre-suit investigation, and only the hospital has now determined that they think he's negligent, and they're perfectly permitted to go forward with that, but the Howlands don't intend to prove his negligence at trial. I wanted to go back to Judge Smith. You talked a little bit about the evils potentially of having to rule that, well, one corroboration might apply to many things. And I think the case law tries to address some of that by making sure any extension, any additional allegations still kind of relate to what was in the pre-suit, that you had notice of what you were supposed to be looking at, which is here. But there's also the opposite potential of saying that every single thing has to be corroborated when it's impossible at that stage in the litigation, and when the corroboration is only supposed to be about reasonable grounds of negligence. So no court at this point has gone so far as to say you have to have an expert corroboration on each possible person who treated the person. Maybe that's where we're headed, but right now, that's not what the statutes say. And there's also a danger here of saying that the plaintiff has to somehow make sure they corroborate anybody who might be later named as a Fabre defense. But I think those potential evils are best addressed by the legislature. If the legislature feels there's a gap here, that they need to more fully connect the corroboration requirement to every professional who is ever implicated, then the legislature could do that.
At a minimum, I take it there must be some pre-suit process. What if there's an individual that's at the hospital visiting someone and slips and falls at the hospital, and then is treated, sues for the premises case, and then says, well, wait a minute, I think there was also medical negligence. Now, Stuart Rehertz might take us out of that, but would that fly?
Well, I think the problem with that hypothetical is one might not be medical negligence and one is, and so you would have to pre-suit one, but not the other. But let me take it more closer to the facts of our case. Do I contend that Mrs. Howland, having pre-suited this allegation that there was failure to diagnose and treat her punctured rectum, can 6 months into the litigation add a claim that on discharge, nurse so-and-so gave her medicine that caused some entirely different injury. No, I think the case law does try to address that. You have to make sure that there was some notice there. Now, whether it gets you cert because you're not dismissing all the claims, I don't think it does, but there's some protection that can be afforded there. But when the claim is in line with exactly what you preceded, exactly what everybody was investigating, then I don't think there's a departure from the essential requirements of law. I don't, even if the amendment was permitted on the behalf of the plaintiff. I also think you can't get a departure from the essential requirements of law when this defense, negligence comes up as a defense. And I think there's perhaps two separate interpretations.
Let me ask you something, because I think you said earlier that you do not intend to prove at trial the negligence of Dr. Freed. Is that correct? So what if there is no cert jurisdiction and the case proceeds to trial? They present their and the jury finds that Dr. Freed is liable, let's just say 20%, and the hospital is liable for that 20%. If you are wrong on the merits that we're here on today, wouldn't the result be not a remand? Let's say, and then there's an appeal, it goes up to here, and the appellate court disagrees with your position today that, in fact, you did have to pre-suit as it relates to Dr. Freed. Wouldn't the remand just be reduce the judgment by 20%?
I think that's potentially true, and another reason why this is all remediable at the end of the case. If there's an error here,
so you wouldn't be here saying we want that 20%. Is that what I'm hearing?
I can't imagine, as your hypothetical goes. I don't. If the court ultimately finds error in, permitting this vicarious liability,
90%, you might be wanting to say something different at that point.
Right. Well. But I think ultimately it still comes down to, if there's a remedy here, everybody can make those arguments in the final appeal. This litigation is going to go forward against the hospital under any circumstance. And there's certainly no harm posed to the hospital by the lack of a pre-suit corroborating affidavit when, in fact, the hospital is the one going to assert that negligence. I think that I've answered most of the questions, but if there's not any others, we would respectfully request that the court treat this as a petition for certiorari and either dismiss or deny the petition.
May it please the court, and I'll pick up with that concept because whether it's 20% or 90% or 1%, that the plaintiff wants to hold the hospital responsible for that percentage. And
but I understood her to say that we're not going to be seeking to prove Dr. Freed's negligence. So meaning if there's no cert jurisdiction, it goes back and the case is tried and you're ultimately correct on the issue of, it would seem that the case doesn't need to be retried. You just take off Dr. Freed's percentage.
No, I would submit it's an empty statement when they're seeking to prove agency and hold us accountable for whatever, they say that, but it's in their pleading as an affirmative claim to hold him responsible.
If it was an avoidance, are we here? If it's just a reply to an affirmative defense, meaning kind of what I laid out to Ms. Norris, would that be a problem? If it's just an avoidance of the affirmative defense, meaning they couldn't seek affirmative relief for the alleged negligence.
I thought that through, and I think they have to plead it because it's agency.
Well, they would have to
has
plead
to
it,
be,
but in response to your affirmative defense, not necessarily as an amended claim for affirmative relief.
I would take the position that they did what they had to do. Whether they did it as an avoidance, I'm not sure if we'd be here or not, because I think an avoidance means you just can't bring this affirmative defense. What they pled was that we're holding the hospital liable based on whatever your evidence shows. I want to, unless Your Honor had more questions. I was just going to briefly go back to this concept of what happened at pre-suit and the alleged sandbagging. The hospital, and I'll just, again, repeat that.
I don't know that anybody up here has suggested that the hospital was sandbagging in this case. I think the concerns are of a potential ruling in the hospital's favor in this particular case that could lead to that sort of behavior in the future.
Or in the plaintiff's favor to be.
Certainly.
Thank you.
And I do think the facts show here at least that nobody's, it's not creating any type of rule in that respect. Dr. Freed is not, I mean, he really isn't, and I know it's maybe not for the court today, but he's not an agent of the hospital, and so it's not like under HIPAA, they can reach out and talk to him during pre-suit. I'll put that out there. I know it's not really, made an issue in the record, but I'll say this much. It's not the hospital's obligation to take radiology records during pre-suit and decide whether they need to find out if there's a basis from testimony to support a radiology claim against them. That's the plaintiff's responsibility. So to the extent everyone had the radiology records, who does that fall on? Plaintiff could have done, more investigation of.
Counsel, I guess, if we were to find in your favor, doesn't that work a manifest injustice in this case because the trial court intended to do a dual step here of allowing you to add the fabre, but also allowing them to raise the vicarious? The trial court had to go through this analysis of whether there was going to be prejudice by allowing your amendment in the first place, and appeared to balance that prejudice by saying, I'll do it if they can then add a this agency vicarious liability claim. If we give you a win, don't we have to go back to the trial court and say you get a second crack at this whole original ruling that you made? Otherwise, aren't we creating manifest injustice by breaking in half what appeared to be the trial court's balance to allow you to have your amendment in the first place?
And sure, and originally the trial court did not find that she needed to balance it in that respect. She applied the law and said, I free granting of amendments. They get that. And the law says I have to dismiss this claim. So she was fine to do that. It was only because the plaintiff convinced the court that the law required her to reinstate the claim that she did so. And there is no manifest injustice here because, again, one is just a defense that only applies if the hospital's otherwise negligent, the fabre. The other is seeking to hold the hospital liable. And on that, I don't think either side has cited to a single case out there that deals with pre-suit and reverses on plenary review. I mean, I just think we have to take these things as they come and deal with them so that they don't go forward like this. And we would submit that was the whole point of Carmody and the rule. It looks like I'm over Your Honor's time. Thank you for the time, and we would ask for reversal.
Thank you both for the clear level of preparation that went into the briefing and the oral argument today. We'll take the case under advisement.
Thank you.